Topic: Montana state liquor laws continued. Information to be covered in this module. Number 1, compliance with laws and rules. Number 2, refilling of liquor bottles is unlawful. Number 3, sales, service, and consumption of alcohol. And number 4, required signage. Compliance with laws and rules. Number 1, all licensees, their agents, and employees must conduct the licensed premises in compliance with the rules of other state and local agencies and abide by all A. provisions of the laws of Montana and the United States related to alcoholic beverages. B. County and city or town ordinances related to alcoholic beverages. C. Indian liquor laws applicable within the areas of Indian country as defined by 18 U.S.C. 1151, provided a tribe having jurisdiction over such area of Indian country adopted an ordinance certified by the Secretary of the Interior and published in the Federal Register, and D. Rules of the Department relating to alcoholic beverages. 2. Proof of violation by a licensee or the licensee's agent or employee of any of the provisions of the above laws, ordinances, or rules is sufficient grounds for revocation or suspension of the license, and licensees may be reprimanded or assessed a civil penalty in accordance with 16-4-406 MCA. Number 3, the Department will impose progressive penalties for multiple violations of any laws, ordinances, and rules within any 3-year period unless mitigating circumstances indicate the penalty should be reduced or aggravating circumstances indicate the penalty should be increased. Violations and progressive penalties include, but are not limited to, those posted on the following chart. Any combination of 4 of the violations listed below occurring within a 3-year period could result in a license revocation action. The first offense has its monetary penalty. The second offense, the monetary penalty. The third offense, if you're not getting it by now, you have a monetary penalty as well as an administrative penalty. And the fourth offense, of course, you have lost your license to serve or sell alcohol. Farther down, you'll see the penalties for a licensee or employee without valid alcohol sales and service training certificate, an undisclosed ownership interest, or the 90-day non-use without approval. Take a few minutes to study these. A penalty for a licensee or licensee's employees not having a valid alcohol server training certificate shall be assessed against the licensee for whom the employee works at the time of the violation. The penalty for this violation is imposed against the licensee, and the licensee having multiple untrained employees on a particular date shall not be considered multiple violations. However, continued noncompliance on a future date may be considered as an additional violation of the server training requirement. The penalty shall be assessed in addition to any penalty and or other Montana Alcoholic Beverage Code violations such as sales to underage persons and or sales to intoxicated persons, and the violation will be considered a separate violation by the department. Penalties for not having valid alcohol server training certificates may be taken into account based on the mitigating factors described in 8 when determining a licensee's total number of violations in a 3-year period for purposes of the progressive penalty schedule seen in 6. However, the monetary penalty for each server training certificate violation shall be $50 for a first offense, $200 for a second offense, and $450 for a third offense in a 3-year period. Example: if a licensee has one previous violation for sale after hours and later violates the training certificate provision, the licensee will be penalized $50 for the training certificate violation, although the citation will be considered a second violation on the licensee's record. Then, if the licensee commits another violation within the same 3-year period, for instance, a sale to an underage person, the penalty for that violation will be a third violation penalty. Number 8. Mitigating circumstances with regard to Title 16, Chapter 4, Part 10, MCA are considered as follows. A. The mitigating circumstances provisions of 16-4-1008 MCA apply only to violations of Title 16, Chapter 4, Part 10 MCA and not to other violations. B. Neither cost nor convenience of training shall be considered by the Department to excuse any licensee from compliance with the requirements of Title 16, Chapter 4, Part 10 MCA and these rules. C. Any violation of 16-4-1005 MCA occurring prior to April 1, 2012 will not be taken into account in determining the licensee's number of violations in a 3-year period. D. In the Department's discretion, a violation of 16-4-1005 MCA occurring on or after April 1, 2012 may not be taken into account in determining the licensee's number of violations in a 3-year period if all managers and supervisors of persons who serve or sell alcoholic beverages meet the training requirements, the licensee demonstrates to the Department's satisfaction that its business policies and practices reflect substantial compliance with the server training requirements such that it is apparent that the violation was the result of an oversight or mistake, and the licensee has committed no previous violations of 16-4-1005 MCA. Mitigating circumstances in the case of sale to an underage person could result in a reprimand for the first offense under Title 16 MCA within the most current 3-year period if the licensee has provided alcoholic beverage service training acceptable to the Department to all of its employees and reinforces that training with each employee at least every 2 years. The licensee must demonstrate that the person who made the sale to a minor has completed alcoholic beverage service training prior to the Department considering the issuance of a reprimand. A written reprimand will be considered a first offense for the application of the progressive penalty schedule only if the licensee commits the same offense again within 1 year. The written reprimand in lieu of a violation shall be available only one time per licensee. Number 10. Aggravating circumstances may result in the imposition of maximum monetary penalties, maximum suspension time or revocation, and will not bind the Department to the progressive penalty framework indicated in 3. Number 11. Aggravating circumstances included but are not limited to A. No effort on the part of a licensee to prevent a violation from occurring. B. A licensee's failure to report a violation at the time of renewal. C. A licensee ignoring warnings issued by a regulating authority about compliance problems. And D. Recurring sales to underage persons or sales to intoxicated persons. E. A licensee's failure to timely respond to requests during the investigation of a violation. And F. A violation's significant negative effect on the health and welfare of the community in which the licensee operates. Number 12. If the violation discovered is an undisclosed ownership interest, the Department will consider aggravating circumstances described in Number 10 and mitigating circumstances such as voluntary disclosure of relevant acts in determining the appropriate penalty. Number 13. Nothing in this rule prevents the Department from revoking, suspending, or refusing the renewal of a license if revocation, suspension, or refusing renewal are expressly allowed in law or rule with reference to a prohibited act.